Section 7 deals with the form of application. As we had already mentioned, the prescribed forms are contained in the second schedule of the rules, and for everything there is a form. Almost for anything that you need to do, there is a form, and there is also a form if you are not sure which form to use. There is a form to use where there is no form prescribed. It's quite comprehensive in that sense. 7.1a deals with international application under the PCT or the Patent Cooperation Treaty, which merely states that an application filed designating India shall be deemed as an application under the Patents Act, provided a corresponding application has been filed before the controller in India. 7.1b mentions that the date of filing the application referred to in subsection 1a and its complete specification processed by the Patent Office as designated office or elected office, these are terms which are used in international filings, shall be the international filing date accorded under the Patent Cooperation Treaty. Section 7.2 states that where the application is made by virtue of an assignment of the right to apply for a patent for the invention, there shall be furnished with the application or within such period as may be prescribed after filing of the application proof of right to make the application. Rule 10 is the corresponding rule. Now 7.2 tells us that the proof of right has to be made, has to be furnished either with the application or within such period as may be prescribed after filing the application. That is prescribed in Rule 10. Subsection 3 states that every application under this section shall state that the applicant is in possession of the invention and shall name the person claiming to be the true and first inventor, and where the person so claiming is not the applicant or one of the applicants, the application shall contain the declaration that the applicant believes the person so named to be the true and first inventor. All these details you can find in Form 1. Now this largely describes certain things that are contained in Form 1. There is a requirement that the applicant who makes the application has to show that the applicant is in possession of the invention. 7.4 talks about what should accompany an application when a patent is filed. So the rule in patent law is that Form 1 has to be filed along with Form 2. Form 1 is the form that is used for making an application for grant of a patent, and Form 2 is the form that is used for a provisional or a complete specification. Patent specification is the document that encompasses or describes the invention. There are a whole lot of parts in a patent specification. The patent specification describes the invention and it ends with one or more claims. It has a title, there is an abstract. So the formal document that encompasses the invention for which a patent is sought for is what we call the patent specification, and the patent specification can either be a provisional or a complete. Now here in 7.4 it is mentioned that every such application, not being a convention application or an application filed under the PCT, Patent Cooperation Treaty designating India. So these two are the kinds of international applications. An international application can either be a convention application or it can be an application under the PCT, Patent Cooperation Treaty. Except for these two, every such application shall be accompanied by a provisional or a complete specification.